This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about MedPay and why the 11th Circuit Court of Appeals read the policy issued by State Farm as it was written and found that MedPay is only available for reasonable and necessary expenses relating to an auto accident and is not health insurance. Kimberly Sisia appealed the district court's dismissal with prejudice of her amended complaint against State Farm, as well as the district court's denial of her motion for conditional class certification. In short, Sisia sought reimbursement from State Farm for medical expenses allegedly occurred because of an automobile accident that occurred in 2009. She claimed that her automobile insurance policy required State Farm to pay all of her medical expenses stemming from the accident up to the policy limit. In Kimberly K. Sisia versus State Farm Mutual, the United States Court of Appeal for the 11th Circuit on June 6, 2024, resolved the dispute. Sisia's automobile insurance policy stated that State Farm will pay all reasonable medical expenses incurred for bodily injury caused by an accident, and that these expenses are for necessary medical, surgical, x-ray, dental, ambulance, hospital, professional nursing, and funeral services, eyeglasses, hearing aids, and prosthetic devices. It further explained that State Farm has the right to review, quote, medical expenses and services to determine if they are reasonable and necessary for the bodily injury sustained in an automobile accident. Sisia argued that the policy unequivocally required State Farm to pay all of the plaintiff's medical expenses incurred from her automobile accident. Sisia's argument ignored the plain text of the policy, which unambiguously stated that State Farm must pay only for expenses that are reasonable and necessary. The policy explicitly contemplated the possibility that State Farm will not pay for medical expenses that are unreasonable or unnecessary. Because the language of Sisia's insurance policy plainly does not require State Farm to reimburse all medical expenses, only those expenses that it deems reasonable and necessary, the district court did not err in concluding that Sisia's claim for breach of contract against State Farm could not survive a motion to dismiss. Likewise, the district court did not err in dismissing her claim that State Farm breached its duty of good faith and fair dealing. Such a claim is not actionable unless the allegations of breach are specifically tied to the breach of the contract provision. There can be no breach of an implied covenant of good faith where a party to a contract has done her complaint because her underlying claims lacked merit. In my opinion, the 11th Circuit, like the United States District Court, did what the plaintiff did not do. They read the policy. Sisia wanted payment for all her medical expenses, while the policy only allowed for payment of reasonable and necessary medical expenses relating to the accident. Therefore, treatment for the common cold, a hangnail, diabetes, or an illness not reasonable or necessary as a result of the accident could never be covered. Sisia was therefore unable to change an automobile MedPay policy into a health insurance policy. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week. And you'll also gain access to the more than 4,800 blog postings. You can also subscribe to the videos on YouTube and rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.